Good evening, everyone. Welcome to the Cannabis Regulatory Commission's Recreational Cannabis Statewide Informational Webinar. Really excited that you all have joined us this evening. It looks like we've got over 850 participants joining us today. So we're really happy to come to you this evening to talk about our rules and what businesses should be aware of. So a few disclaimers before we get started. This webinar is for informational purposes only. While the CRC is going to provide as much information as we can particularly for those individuals who are looking to submit an application for cannabis business licenses. The information that we are going to share should not be construed as legal advice. It is not business advice. And there will be another webinar specific to applications that we'll discuss a little bit later on. But we want to come to you today to really give an orientation overview of what to expect and how businesses can prepare for applications. So we'll start off. I'm joined today by our Executive Director, Jeff Brown, and our Vice Chair at the CRC, Sam Delgado, and we have staff who have also logged on as well. So they'll be helping us, operate this evening, and we'll be taking notes on questions that are asked. So don't be shy. Use that Q&A button at the bottom of the Zoom screen if you have questions that you would like to have answered. So as we go forward today, we'll start off with an overview of the initial rules that were established by the Commission on August 19th. Then we'll kind of give a high-level overview of the basic application requirements, provide expectations for the background investigations that the Commission will conduct as part of the application processing process. And we will also want to spend a lot of time talking about what businesses can do to prepare for applications. And then we'll also have some information about management service agreements and financial source agreements. We know that there have been a lot of conversations about these agreements, and so we want everybody to understand what they are and what they should be looking out for. And then finally, we'll talk about some expectations for the neighborhoods that will have cannabis businesses, and then what comes next as we move forward from here. So again, really excited to dive into these items with you all this evening. This is not, I'll reiterate, this is not to be construed as legal advice or business advice. If you have questions that are specific to your circumstances, then we suggest that you contact your own attorney to figure out what options may be available to you. So with that, I will now turn it over to our Executive Director, Jeff Brown, to talk about the initial rules.
Thank you, Madam Chair, and good evening, everyone. Hello, Vice Chair Delgado. So I'm going to cover a high-level overview of the initial recreational cannabis rules as adopted by the Cannabis Regulatory Commission over the summer on August 19th. Notably, these rules were the culmination of a lot of hard work from the time that we established the commission in April to the time that the commission voted on those rules in August. They were also a starting point because they are not meant to be the end all be all. They are not meant to be an end point. They are meant to be a beginning point of this process to establish the new legal recreational cannabis industry in the state of New Jersey. So I do want to cover, some of the initial focal points in those rules. First and foremost, true to our two core values of equity and safety, we really sought through all aspects of the initial regulations to emphasize both social and economic equity and safety. And that's whether we're talking about prioritization in the application process, which we'll outline a little in a bit, or talking about product safety when it comes to vape cartridges, manufactured products, and product testing that people can have confidence in. We really wanted to make sure that equity and safety ran through all of these things. The application process for cannabis businesses is outlined in full in those rules, and as is the fee structure. And we wanted to be transparent so businesses know how to prepare, what they'll be on the hook for as far as application fees, and what they'll be on the hook for as far as submissions as a part of the application process. And we'll talk a little bit more later about what comes next there. And lastly, we really wanted to make sure that we were setting up rules that really responded to the unique challenges that our municipal partners have in this, and the fact that this is kind of a two-step process where we'll have licensing at the state level, and then municipalities are going to have to weigh in and make a number of decisions, which Vice Chair Delgado is going to talk about shortly as to what can and can't happen within their borders. So in the statute, there are 6 classes of cannabis businesses, and then also licenses for testing laboratories. They're class 1 cannabis cultivators. Those are licensees responsible for cultivating the raw plant material, either packaging it and selling it to wholesalers or retailers, or selling it to manufacturers to then to produce into cannabis items, either ingestible cannabis products or cannabis extracts. They're cannabis manufacturers who really take raw material and move it, take it from that raw form and move it to a more finished product form, whether that's an ingestible product, an inhalable product, or a raw cannabis extract. The statute sets up cannabis wholesalers and distributors, and those are 2 sets of licensees who, each have kind of a piece of helping cannabis products move in bulk throughout the system. So between cultivators and manufacturers, or between manufacturers and retailers. That's really the role set out by the statute for wholesalers and distributors. And then finally, there's retailers and delivery services. And these are the businesses that will be really responsible for serving the consumer, whether it's at a brick and mortar retail store in the case of a retailer, or whether it's via home delivery in the case of a cannabis delivery service. And then finally, we have testing laboratories, which will be licensed to test all the products that are sold in the market. So as far as equity in the rules, I'll cover a few key components here. So first and foremost, the rules feature priority review for applications from target groups. These include social equity businesses, diversely owned businesses, and impact zone businesses. There's also a focus on market access for a diverse set of entrepreneurs. And I'll just note here, because we do have an agenda item on our meeting on Friday about the RFA that we're in the process of wrapping up. What we're going to be doing going forward is going to be dramatically different than what we've done in the past. And that's because we want to make sure that when businesses are ready to access the market, ready to get in and get going, that we're processing those applications and moving them forward, and where they meet all the requirements, they're being licensed and gaining access to that market. So a piece of this is low application fees and competitive licensing fees. So initial application fees can be as low as $100. And then licensing fees range from $1,000 for micro businesses up to $50,000 for large cultivators, but really are structured to be competitive and to help people get into this market and stay afloat, particularly in the early days. The rules contain protections for license holders from predatory practices. So, we've certainly seen around the country when you set up programs to try and prioritize or get access to, entrepreneurs into the market. Certainly there are folks who will try to use that to their advantage to potentially qualify for things when they shouldn't, or otherwise, target, go after, new businesses to try and get them to sign deals that might not be in their best interest. So we include protections for license holders, license applicants in cases where that may be happening, which we'll cover a little bit later, as our chair mentioned, when we get to management services agreements and financial source agreements. And then finally, there are community benefits. Importantly, this industry is going to generate tax revenue in the form of a sales tax. The rules also establish the social equity excise fee, which is a fee on cultivated product that will then be invested into communities around the state and cover a various numbers of and various activities related to community benefit. So again, diving in on those three business types that are prioritized in our rules. The first are social equity businesses, and these are applicants who meet one of two criteria. So they either live in an economically disadvantaged area, which is a zip code in our state where there is lower than average median household income and higher than average rates of uninsurance. So you can qualify by if you've lived in one of those economically disadvantaged areas and currently are at 80% of the median household income, or importantly have passed cannabis related criminal offense or offenses, 2 or more disorderly persons offenses, or 1 or more indictable offenses. Individuals who have cannabis related criminal offenses in their past will be prioritized in this licensing structure. Diversely owned businesses are businesses that are certified as minority owned, woman owned, and or disabled veteran owned, and certified by the Department of the Treasury here in the state of New Jersey. And then there are impact zone businesses, and impact zones are set in statute. So this is not something we created in rule. It was set by the legislature, and they are essentially municipalities around the state that have some combination of high numbers of marijuana arrests, as well as potentially high unemployment, high population, and a few other factors. But individuals and businesses can also be prioritized based on qualifying as an impact zone business, and that's either located in an impact zone, the owners of the business live in an impact zone, or they commit to hiring and have employees that are predominantly from the closest impact zone to the business. So there are 2 types of cannabis licenses. So I went through the classes of licenses. I want to make sure people understand that the 2 types. There are conditional licenses and there are annual licenses. Conditional licenses are temporary licenses issued to new businesses that allow them to get an initial thumbs up from the CRC. It gives them up to a 5.5-month runway, 4 months off the bat, and then the commission can extend it for an additional 45 days to apply for a full annual license via converted conditional license. And so the things that a conditional license doesn't need, that an annual license does need, are site control and municipal approval. So if you're just getting into this industry and you meet certain income requirements related to conditional licenses, i.e. As an individual, you made less than $200,000 in the last year, or if filing jointly over $400,000 or under $400,000, then you can look at the conditional route as an initial licensure to get an initial approval from the commission, and then have some time to apply for your full annual license. An annual license, on the other hand, there you need site control and municipal approval when you come to the commission to apply. So that means you need to have a site, you need to control it, you need to be ready to go, and you need to have all your municipal approvals locked up. So conditionals, that's a temporary license up to 5.5 months, 4 months guaranteed, an additional 45 days potential extension from the commission. And then an annual license, there you need full site control, full municipal approval, and have to go through a full application process as outlined in regulations. Notably, for annual licenses, based on what's in the law, there are some measures that require you to talk about, kind of past business experience, whereas in conditional, we've given the ability for newer businesses to focus strictly on things like developing the proper standard operating procedures that our compliance team is going to want to see when you get into the market, and bypass some of those measures that may be required of a full annual licensee off the bat. So I'm going to turn it over to Vice Chair Delgado now to talk a little bit about municipalities, but I do want to note that we are recording this webinar and it will be available on the website, on the CRC website, www.nj.gov/cannabis, tomorrow, as well as some additional resources, which we'll cover before the end of this webinar. Vice Chair Delgado, please take it away.
Thank you, Jeff. Thank you very much. And good evening, everyone. And thank you thank you for participating in tonight's webinar. I just want to remind everyone once again what Chairwoman Wainu mentioned at the beginning of our webinar, and that's that this webinar is specifically informational purposes only. It's not intended to be legal or business advice. So with that said, for me, the most important, if we could just leave it on slide number 9 for the time being, and then we'll go back and we'll move forward. Yeah, for me, the most important piece of information that I can give you from my 21 years in dealing with municipalities is to know the municipality that you're going to be establishing your cannabis business in. Know the playing field, know the game, know the players. So in the next 3 slides, what I'm going to try to provide you is a brief overview of what municipal authority covers pertaining to cannabis industry. Yeah, so the municipal authority covers things like zoning and regulations and approval for reasonable fees. They cover the number and kinds of cannabis business licenses that they will allow in their particular jurisdiction. They have authority over the business operations, like when you can open, when you can close, business hours. They also have the ability to enact up to 2% transfer fee tax. They weigh in on the CRC selection process with preference, and there'll be more to that later on. And they also are responsible for passing and updating their ordinances. Next slide. So it's important to understand the 3 centers of decision-making in your local government, in the municipalities, especially that deal with cannabis. We'll be dealing with the cannabis industry. So the first one is the local governing body, all right? And what I mean by the local governing body is the city council in whatever form of government the municipality has. And the city council really determines what to include in the town's budget, taxes to be levied on residents and businesses, and what should be legal or illegal within the town. So you can see that that's important for making the decision on whether a municipality is going to allow your business in their town. It also includes, they also include the mayor and elected officials such as city council people, and also appointed administrators or hired administrators such as the business administrator, and also the corporation council for the town. The next center of local government, decision-making in local government, is the planning board. And that the planning board controls the physical structure of the community, really, and also the environmental quality, any kind of future development, the city plan. Its makeup may include non-residents, non-elected residents of the community. Volunteers are also included in the planning council, municipal employees, and generally there's generally a space for an elected official. So the planning board is very key to getting approval within the municipality, because it really affects that environmental quality and physical structure of the community. And finally, the zoning board. Now, the zoning board is an independent, partly judiciary body that issues zoning variances and rules on zoning appeals. It rules on different zoning appeals, whether an appeal goes through or not, and also interprets the municipal master plans. Its makeup is similar to the planning board. It's made up of non-elected residents, volunteers, municipal employees, and also generally there's one spot allocated for an elected official in most planning boards. If we can go to the next item. So what do we need? What does an applicant need from the business in order to do business in the municipality? The CRC, the rules in the CRC, an applicant must have both of these. One, a letter or affidavit from a zoning officials indicating that the applicant's proposed location is compliant with local zoning requirements. So you see, that's where the zoning board comes in, okay? And two, a municipal resolution or letter from a municipal executive indicating that the intended business location is appropriate for cannabis activities. So a municipal executive could be the mayor it's generally the mayor of the town, and depending on the type of government the town has, it could also be the city council president in the town when they have a rotating kind of mayorship in that town. And applicants, finally, applicants for the annual licenses must have both. So it's important that we remember that. And I'll turn it back over to you.
Yes, thanks, Sam.
Jeff?
Thank you. I appreciate it. So real quick here, just going to run through some of the basic application requirements covered in the rules. So Vice Chair Delgado mentioned two of them for annual licenses, which is that zoning affidavit and the either the resolution or letter of municipal approval. Importantly, the initial rules do cover licensing requirements for all cannabis businesses. They don't have fees for wholesalers, distributors, or delivery services, and we only covered complete operational requirements for cultivators, manufacturers, and retailers. Although delivery services and distributors, and to an extent wholesalers, I think are covered a little bit in some of the provisions that are applicable to all cannabis businesses, whether it relates to secure storage, secure transport, or home delivery. I will note that once you dig into the application requirements in our rules, you'll notice that we are asking for a high level of transparency, and that's really the key to being successful in this application process. I think obviously they're the business components, but when it comes to the regulatory side, we really want to know who's involved in the business. We want to understand your financing. We want to understand whether you have a company that you're contracting with to run part or all of your business, who that is. So we do ask for a high level of transparency. So, coming in, I think it's helpful to understand that that's a part of the process. It's consistent with what has happened in medical cannabis and consistent with what happens in other states as well. I will note that certainly high on our priority list when we talk about our next set of rules are those wholesaler operational requirements, distributor and delivery service operational requirements, so that we can have the full slate of cannabis businesses ready to go here. On that note, I think it's helpful. We wanted to just provide some ideas for preparing to start a cannabis business in New Jersey, and I'm going to pass this back over to our vice chair to run through.
Thank you very much. So let's start with again, I firmly believe that if you want to start a business in New Jersey, the very first thing that you need to do is know the law and the regulations. There's a lot of misinformation out there, but if you go to the CRC website, you can download a summary of the regulations that we enacted back in August. You could also download the regulation, the actual regulations themselves, and you can download the law. So the CREMA law. So knowing the law is key before you decide to, dip your feet into starting a business. So, and identifying first first item is to identify what kind of business an application you want to use. As you can see, there are different kinds of activities. There's the cultivator, there's the manufacturer, the retail, the delivery, the distribution, the wholesale, and then the testing labs. Then you want to go understand what size of business. Do you want to do the standard size? Are you eligible to do it standard size, or are you going to go to the micro businesses? Now, obviously, the micro businesses are any businesses. If you read the law, it describes exactly what the micro businesses are under a certain amount of square feet and a certain amount of employees. And then the application process, be an application ready, whether you're going to go conditional, and Executive Director Jeff Brown just explained what conditional means, or are you going to go with the annual? Keep in mind that with the annual, you're going to have an annual fee. Conditional, you have a 5.5 month window to a preparation in order to get all your zoning requirements in line, to get your municipal consent in line, with an additional 45 days. And then the annual means that you're ready to go, and you're going to try to get to start your businesses right away. We can go to the next slide. Now your business plan. In preparing a business, you should have your business plan ready. And the reason for that is your business plan really is the foundation of your business. It's a roadmap. It's a roadmap for how to manage your business. You'll use the business plan. I know I used my business plan when I was doing my business, when I had a business, about 30 years ago, on how to structure, and I used it to how to grow my business and think through some of the key elements of how to do my business. My business plan really also helped me in funding, and I'm bringing on new business partners or investors. So think of it that way. Think of a business plan as a roadmap. Your business plan is a tool that you use to convince people that working with you or investing in your company is a smart choice. Okay. Some items in a business plan can include a marketing and research portion that includes customers and buying habits, cannabis business operation, budgeting and pricing, financing. But a formal business plan, I have to emphasize this because this is key. A formal business plan is required as part of the conditional license applications. So if you're going down the conditional route, where you want to get a conditional license because you don't have all your elements up to speed or ready, things like the municipal letters approval, you do need a business plan in order to move forward. So that's going to be important. And then next item is deciding on what kind of legal structure, business structure you're going to put together. Whether it's a partnership, and partnerships are basically a simple structure for 2 or more people to own a business together. Then there's, I want to go to corporations before we touch on limited business partnership. I want to talk about a corporation, and a corporation is basically a legal entity that separates the owners from the liability of the corporation. All right. So corporations, they can make a profit, and they can be taxed, and they can be held legally liable. However, the people, the the individuals in the corporations cannot not be held legally liable based on the corporation. So the corporation offers a strong protection to its owners from personal liability, but the cost to form a corporation is usually higher than other structures. Corporations also require, you know, a good amount of record keeping. So keep that in mind if you decide to go the corporation route. They require a good amount of record keeping and operational processes and reporting. I want to talk a little bit about S corporations, which is a special type of corporation that is designed to avoid the double taxation and the drawback of a regular corporation. I know now this is all a lot. There's a lot of information I'm giving you here, but I suggest that you go ahead and do research on by yourselves and to understand what an S corp or an S corporation does. It allows profits and some losses to be passed through directly to its owners' personal income without ever being subjected to tax rates. Okay, a corporation, an S corporation, allows those profits and loss to be allocated to your personal income tax, whereas a corporation could be taxed twice, maybe be able to be taxed twice, once as a corporation and also as the dividends that are passed on down to the dividend holders. Okay, so that's what the difference between the corporation and an S corp. What I want to talk about now is get back to the LLCs, limited liability corporation, and that lets you take advantage of the benefits of both the corporation and partnerships business structure. LLCs protect you from personal liability. In most instances, your personal assets like your vehicles, your home, and your savings, and won't be at risk. LLCs, in case your LLC faces bankruptcy or lawsuits, profits and losses can be passed through to your personal income without facing corporate taxes. However, and here's something that everybody should be aware of. Members of the LLC are considered self-employed and must pay self-employment tax and contributions to Medicare and Social Security. So that's kind of the overview of the 4 types of business structures that you can consider: partnerships, limited liability, corporations, and S corp. Now, the next step, once you decide what kind of legal business structure you're going to be involved in, the next step is to get your federal ID and your state tax ID. Your employer identification, your EIN number, is your federal tax ID. You'll need that to pay your federal taxes, hire employees, open a bank account, and apply for business licenses and permits. So that's key. You will not be able to do anything. You will not be able to go forward in doing anything in your application process or in your business process without first having an employee identification number from the federal government. It's free. You can apply for an EIN number directly at the IRS website. So, and there's also, at the end of this, we'll have a couple of resource pages with some URLs where you can find the URL and go online to apply for your EIN number. You also need a state ID to pay your state taxes, and that can be gotten in New Jersey through the New Jersey State Department of State portal under the Treasury Department. We can go to the next slide. Getting your name registered, registering your business and business name is important. Again, you can register your name with the state of New Jersey at the State Treasury, New Jersey State Department. under Treasury. You should also check your local county clerk to see if you need to register your name with the county. Some counties require that. I know when I was registering my business up in Essex County required that, and I needed to go. I had to go up to the county clerk's office and look through various books to see that there was no duplication of names. And in the books that had the same name as my business, so that I can register my business with the county. So that's key. And finally, you should also reserve your domain name for a website, and that's key. Google domain is one. There are various domain applications out there, portals out there that you can register a domain. Google domain is one of them. I'm sure when you're doing research on creating websites, the Google domain name is the one that generally pops up. And a note, a cannabis business can only operate under the name of the licensee. The legal entity name as it appears in the New Jersey business registration. A cannabis business cannot use or display, advertise, or operate under any alternate name. For example, doing business as, if you're doing business as, say, Sam Delgado, you can't use that name. You have to use it. You have to use the name that under your license. So that's something to keep in mind. Open a business account. Step number 6. Note there are banks in New Jersey. There are currently, I think, 2 banks in New Jersey that are doing, or there were 2 banks. There may be more now that are accepting cannabis business clients. A business bank account, it helps you to keep legally compliant and protected. Documents that you need to utilize when you're opening an account. That first document is your EIN number, your federal tax identification number. You're going to need your state tax identification number, a personal ID, a social security card. These are your business formation papers, if you're incorporated or if you're an LLC or your partnership, your ownership agreements, if there's multiple partners, and then your business registration. These are items that you will need to present to the bank in order to open up that bank account. So keep that in mind. Business insurance. This is something that's going to be required for all cannabis businesses. I know in the rules it's general liability, but keep this in mind. The municipality, the zoning board may require additional insurance, whether it's commercial property insurance, general business insurance. They may require additional fire insurance, additional insurance. So always keep that in mind. And when you work with your municipality, you should be able to identify what kind of insurance that you're going to need in order to operate your business. Okay. Of course, if you're going to be dealing in delivery, if you're going to have a delivery or distribution license, keep in mind you're going to require vehicle insurance. Requirement for any kind of transportation of cannabis or cannabis items, and then workman's compensation. So these are the type of insurances that should be on your radar screen when you start your business. You should be, as you're thinking and as you're doing this, as you're preparing to open your business and to start your business, you should also be thinking about if you're going to be in the retail business or any other part of the business, any other kind of licenses, whether it's cultivating or manufacture. Researching potential locations is very important in each city and town and borough in the state. Remember, they are responsible for establishing their own processes. So as you go out and you either work with real estate agents or work with friends or families and identifying potential, or partners in identifying potential locations, you should keep in mind that each town, each municipality has their own approval process. State control, local approvals, and evidence of zoning approval are required for the annual licenses. So yes, you're going to need, and I mentioned that in the earlier, in dealing with the municipalities and the municipal guidance, you will be needing a local approval. And conditional licenses applicants must identify a potential site, but may change it later. So in the conditional, again, what a conditional license is you're ready for business, but you don't have all your paperwork, you don't have all the zoning approvals ready, you may not have your lease ready. So understand that you must identify the site, but that may change, that could change. And again, you have 5.5 months to get that in order, to make sure that you do have your lease, that you do have your site in order, with an additional 45 days extension. So applying, the next step, I think, yes, applying for certification as a minority owned or woman-owned business, or a disabled veteran-owned business. There are, again, the state has, New Jersey has a state portal that will work you through that. The certification procedures and applications, they are in the Treasury Division. And again, we will have there's the URL right there, but we will have resource pages available up online that can work you through that. So that's key and important. Again, things that you will need with that for that are your EIN number, your business formation papers, your ownership agreements, your business licenses, all, and proof that you are indeed a 51% plus minority, minimum 51% minority, woman-owned business or disabled veteran-owned business applicant. And these are preparation for documentation of proof to qualify for conditional applications, social equity, business impact zones, and businesses and micro businesses. First is the residency. The social equity business is 5 to 10 years in economic disadvantaged area. Impact zone, a current resident and 3 or more consecutive years in an impact zone. A micro business, New Jersey residents for 2 years at a time of application. 51% of ownership must be resident of the municipality the business wants to locate in, or neighboring municipality. Post-cannabis convictions, you need proof of 2 or more disorderly personal offenses or 1 or more indictable offenses. Tax returns, you'll need conditional, for the conditional license applicant must have at least $200,000 single or $400,000 joint flyers in the preceding year. Now, keep in mind, again, this is all under the regulations. When I talked earlier about knowing what the regulations are, it's key that you understand and read those regulations so that you can apply, so that you understand what and be able to prepare documentation proof to qualify for the conditional applications, the social equity business, impact zone business, or micro businesses. Again, excuse me. I recommend that you download those regulations and read through them thoroughly. And then finally, the reviewing application regulations and preparation documents. You're required by license applicants, annual license applicants, probability review for owners, principals, management service contractors, and financial sources, and others. And that's the 10 steps.
Thank you, Mr. Vice Chair.
Yeah, I'll turn it over to you, Jeff. Thank you.
Thank you. Next slide, Tony Ann. Thank you. So just to put an exclamation point on what our Vice Chair said, one of the most frequent questions that I guess get asked is, I could go for cultivation or manufacturing or dispensary. What do you think the best play is? And ethically, I can't answer that question to anybody. I can't share my opinion on that. But the real answer is that you need to figure out what type of business you want to be in there before you really start the licensing process and start the process of actually building the business that you want to get licensed. And that's where everything from the business plan comes in to determining what type of business you want to be. Vice Chair Delgado listed some there. There are certainly others that are permitted by rule as well. I mean, you could operate as a nonprofit corporation provided you met those requirements, and I'd say that's probably more applicable to medical than it is to recreational. But there are additional possibilities there. So looking ahead, and I'm glad that Sam ended on those slides talking about, what to prepare, because I wanted to make sure, go back to my comments on the fact that we ask for high level transparency and talk about expectations for the licensing process and for CRC investigations. So next slide, please. So when we talk about the background investigation process, so it's important to break down licensing into a couple different components. There's the license application itself, and then there's the review of that application. But then there's also components related to the background investigation process. And those are first and foremost, and this is true of every license application that we get, and this happens earlier in the process, a review for statutory compliance. So we covered designations related to social equity business, certain qualifications, as Sam mentioned, conditional applicants have to be making less than $200,000 in the preceding tax year of filing as a single person, $400,000 if filing jointly. Micro businesses, there are residency requirements prescribed by the law, other requirements in terms of limits on employees. And then there are ownership limitations established both in the statute and in our rules. And so, the first piece of this is that if a business is applying as a social equity business, as a diversely owned business, as an impact zone business, or for a conditional license, we're going to need to verify that business and the people involved in that businesses meet all those requirements. So that's step one. I think step two is the criminal history background check that's required by the law. And I'll note a key difference here versus what happens when it comes to medical cannabis. In medical cannabis, there is disqualifying offenses under medical cannabis are much more broad than we have here in recreational cannabis. Medical cannabis, pretty much any high-level felony is going to be disqualifying unless you can prove that you've been rehabilitated. When it comes to the recreational cannabis statutes, things like low-level cannabis offenses are not disqualifying. The only things that are disqualifying are offenses that must be substantially related to the qualifications that an applicant is showing or relying on in running a business. And so we outline some of these in our rules. Certainly the full list could be more extensive, but really when it comes to disqualifying convictions in this criminal history background check, it's a much more finely targeted disqualification versus what we've had in the past. And importantly, like in medical cannabis, here applicants can prove, even if they do have a past conviction that may be considered disqualifying, that they've been rehabilitated. And there are provisions in the statute and in the rules that outline what you would need to do there. Things like references, the amount of time that's passed since a conviction occurred. But importantly, not only are we not disqualifying people for low-level cannabis offenses, whether it's disorderly persons or even indictable offenses, we're actually prioritizing them in the application process when it comes to social equity businesses. When it comes to the additional piece is what we call probity. And this is for, owners, interested parties, some contractors, particularly management services contractors, which we'll talk about in a second, financial sources. But probity is really a look into primarily, where the source of funds came from for the business. Where is the funding coming from? Can we track that back to the source? Is it legal? That's what our investigators are going to be looking at. They're going to be looking at things like business formation documents to make sure that the people who are on the application actually have control of the business. They're also going to be looking at things like professional licensure. Do people have professional licenses in New Jersey or other states? Are they in good standing? Is it a company that has cannabis licenses in other states? Are they in good standing? And certainly, again, the finances, whether it's the finances of the business or the finances of an individual involved in the business. Next slide. So talking about finances and management of cannabis businesses, there are two arrangements that we see in this industry and really any industry, but we certainly see them a lot in the cannabis industry. And those are management services agreements and then, lending agreements. And you see lending agreements in any business, but we do provide in our rules protections for cannabis businesses when engaging in a management services agreement or a financial source agreement. And a management services agreement is basically an agreement between a licensed entity and a non-licensed entity for an outside entity to come in and provide professional services, things like staffing and management services of the day-to-day of a cannabis business. And that's in exchange for fees or other compensation, but not ownership interest, importantly. In our regulations, management services contractors can have up to, but no more than 5 agreements with cannabis businesses. So we do allow for management services contractors to operate here. Certainly, there can be a benefit if people want to have an experienced entity come in and assist with the running of the day-to-day. But we want to make sure these are not avenues for skirting things like license caps and other limitations on ownership. Importantly, cannabis business owners and principals cannot be management services contractors. Next slide. So some of the things that management service contractors can include: management supervision or hiring of employees, help with operations or consulting, technical assistance, accounting or record keeping, leasing of equipment or real or intellectual property, and providing supplies for the business. Next slide. When we talk about financial sources agreements, here's where you have a lender, whether it's an individual or an entity, who agrees to lend capital to a cannabis business, either an applicant or a license holder, as part of a secured or unsecured financing agreement. For financial sources, they can have no more than 7 agreements with cannabis businesses. So they can fund more than one cannabis business, provided that they don't fund more than 7. And some examples of financial sources would be creditors with a secured interest in the cannabis businesses or its premises, or creditors holding an outstanding bond, loan, mortgage, trust deed, or note from the cannabis business. So when talking about those protections for cannabis businesses, the things that MSAs cannot do, and we note these in our rules, they can't essentially engage in practices or include terms in their agreements that would otherwise be deemed commercially unreasonable or unfair. So terms that, such as MSAs and FSAs, cannot impose unreasonable fees, interest rates, or returns. They cannot receive an ownership interest in the cannabis business. They cannot have an unfair advantage over the cannabis business. And so what that means is, provisions in an agreement that would give authority over decision-making to the management services contractor over the wishes of the actual owners of the business. That's an example of an unfair advantage. Another one would be a requirement that a cannabis business devote over 50% of their shelf space to product from a particular other cannabis business. They can't have a percentage of business profits greater than the net profits received by the cannabis business. They can't prohibit the cannabis business from selling to or buying from any company. and they can't require the cannabis business to enter into non-compete agreements. They also can't require the cannabis business they can't have the power to overrule fundamental business operations decisions such as strategic planning. Again, we want to make sure that the license holders are indeed the ones who, at the end of the day, have the full authority to determine the the direction and those fundamental business decisions and strategic decisions. MSAs cannot last for more than 4 years without an opportunity to renegotiate. Importantly, the rules require that these are negotiated at arm's length, and that really means there need to be two parties operating independently here. You can't have two parties with the same goals working with each other. These should be bargained for and negotiated at arm's length. And FSAs can't impose penalties for prepayment or paying off the debt before the term of the agreement. So a lot of companies out there certainly offer either management services agreements or management service contracts, services, or financial offer to operate as financial sources. Importantly, with MSAs, check the document for any prohibited terms and conditions. We outline them clearly in our rules. You can use that as a guide. We'll actually have a document after this webinar, as well as some other documents on our resource page that will give you a quick reference for do's and don'ts for MSAs and FSAs. So make sure you submit all required MSC, management service contract, or MSA documents required by the rules as a part of your application. So if an applicant is going to utilize an MSA, we want to know the personnel involved in that MSA, who's going to be running the business on behalf of the owners or the principals. Those individuals who are involved in the direct day-to-day, particularly plant touching positions, are going to have to consent to a background check. If they have a potentially disqualifying conviction, submit evidence of rehabilitation so that we know they can be approved. And then a completed entity disclosure form, which is a form that we use and will be made available to licensed applicants to disclose information about the management services contractor. And again, clearly communicate with the proposed management service contractor any plans or expectations to audit the records. Certainly, there should be an opportunity for businesses to do that if they're entering into those agreements that concern the agreement. Next slide. So with an FSA, again, check the document for any prohibited terms and conditions. I think for both of those, it's really important to have an attorney who can help you review these documents and make sure you're not signing a provision or a document that you don't fully understand. Again, when you apply, submit all the required financial source documents required by the rules, and these include entity disclosure forms similar to an MSA, in the case of individual personal history disclosure forms, and information related to any changes to the ownership interest or control of the financial source, as it relates to the application process. So here, I'm going to pass it over back to our chair to go over a little more broad content, really expectations for communities that are going to host cannabis business.
Thank you, Director Brown. Yeah, the MSA and FSA information is so important. So I really hope that everyone who is who's joining us today, and now we're at a little over 1,100 people total, was really able to take note of that information. Again, this webinar is being recorded and will be posted on our website. I believe it's tomorrow, as early as tomorrow. So if you didn't get quite everything, fear not, you'll have an opportunity to circle back to the information that is provided here. So for communities, I know that since the state started having conversations about whether or not to legalize cannabis for adults, there has been this persistent question about what this actually means for communities. What should neighborhoods look like? What do communities that have cannabis businesses now, what do they look like? What are they experiencing? And so we wanted to share a little bit with you all here today. Obviously, there will be cultivation, and at present, most cultivation that we see is indoors, but there is a potential for outdoor cultivation for cannabis. So for those businesses that are engaging in indoor cultivation, communities are likely going to see warehouse-like structures or permanent greenhouses, those kinds of things. Municipalities must expressly allow outdoor cultivation if before any cultivation business begins activities related to outdoor cultivation. Now, those outdoor cultivation areas will be required to have additional security and physical barriers. This is really a security measure that is put in place to make sure that we are avoiding or mitigating any risks for deviating cannabis plants away from the regulated market, and are able to make sure that our operators are conducting their businesses safely and securely. From the retail side of things, businesses will look pretty much like other businesses in the community. There is not, retailers will not be allowed to have any additional signage other than their name indicating that they are a cannabis business. But additionally, once you step inside the doors of a retail facility, there are security and age verification measures that are expected to be in place. And so really we are working towards making sure that our operators ensure that their customers and their consumers are of legal age, that is age 21 years and older. And so if you are not 21 years or older, you should not be entering the store at all. So we want to make sure that our operators are adhering to the rules and the laws with respect to their businesses so that communities can feel confident in the legalized industry that we're setting up, and so that we can have responsible operators here in New Jersey. Odors is something that we get questions about all of the time. This is usually only a potential issue for cultivation operators, but businesses are required to use odor mitigation strategies so that the surrounding community is not as impacted by cannabis odors as we've heard some communities have described, particularly in other jurisdictions. Now, there are HVAC systems that have been built specifically for this cannabis industry. Cannabis has a strong odor to it. Those terpenes are hard at work, and we want to make sure that it doesn't become a nuisance or bothersome for the neighbors. So we require all of our businesses to describe and implement odor mitigation strategies, and we hold them to it. We work with our partners at DEP, the Department of Environmental Protection, to ensure that our businesses are operating in this manner. So communities that are experiencing issues, they should feel free to contact the CRC and indicate what's happening in their neighborhoods. And if there's an issue, then our CRC staff and investigators will definitely be available to follow up and act accordingly. So what comes next now for us and for you all, now that you have an idea of what you'll need to be thinking about as we draw closer to opening applications, we want to highlight some of the major milestones that will be coming up for us at the Commission. And so the first is the notice of application acceptance. This is the flag that will be raised high in the air to let everybody know when they can start submitting applications to the CRC for a license. The notice of application acceptance will also detail in specificity what documents are required to be provided. And so if you have a question about what might be included in the application, don't worry. Even if we haven't answered your question tonight, we will be providing additional details in that notice of application acceptance. So we are working to put that together and get that ready for publication as quickly as we can. It will be published in the New Jersey Register. We'll also announce the notice of application acceptance at a CRC public meeting. It'll be posted on our website, and it will be shared through shared with our email list. So we'll be publicizing it as far and wide as we possibly can. One question that we've gotten a lot in the chat already this evening was about impact zones and economically disadvantaged areas, and whether we'll be releasing information, a list of areas that meet those criteria. And the answer is yes. We have already pulled data to identify which communities meet those standards for as an impact zone or an economically disadvantaged area. We're trying to use the most recent available data. The 2020 census was just released, so we're trying to make sure that we are utilizing the most up-to-date relevant information about what our communities look like today. And we're working to verify and corroborate our findings before it gets posted. But we will be sharing information about which cities, which municipalities qualify as an impact zone, and which zip codes qualify as economically disadvantaged areas according to the regulations. We will also be hosting a pre-application information session. We mentioned this at the top of the webinar. This is where the meat of all of your questions related to applications can be answered. So after the notice of application acceptance is published and announced, there will be an opportunity for folks to submit questions to the CRC, and we'll use those questions to help us shape the information that is provided during this pre-application information session. So that'll be forthcoming. Please be on the lookout for that. And that'll contain a lot of information about how you actually work through the software database that's going to be used for submitting your application. And then finally, we'll also have to we'll have to also establish rules on delivery, distribution, and wholesaling. Because the CRC had an aggressive timeline for getting the initial rules in place, we needed to focus those rules on the elements of setting up the industry that were most critical and chronologically come first. So so while we did not include delivery services, distribution, and wholesaling in the initial set of regulations, rules on those and details on those licenses will be forthcoming, and we'll try to get those to everybody as soon as we can. So because we know that we've got a lot of New Jerseyans who are eager and interested in setting up businesses related to those classes of licenses. So we want to get you all the information you are waiting for, but that will be done through the regulatory process. So stay tuned for that. And that really is a highlight of all the details here. The notice of application acceptance, as I said, will be really published far and wide. And so if you have questions that come up once that is published, there'll be information on how you can submit your questions to the CRC before the pre-application information session. And additionally, that pre-application information session will also be recorded and posted on our website so that people can reference it or view it at any time that they wish. Next slide. So where do we go for more resources? If you have questions or if you need more information on the general cannabis business requirements, including some of the stuff that we went through this evening, check out the CRC's website. www.nj.gov/cannabis. If you have questions about exactly how to get your business started, how to register your business with the Department of State, and how, if you have questions about the process for the certifications for minority-owned, women-owned, or disabled veteran-owned businesses, you should look to New Jersey's statewide business support website, business.nj.gov. That is a website that has a wealth of resources and information that is really meant to support prospective businesses and entrepreneurs get up and running and understand how they can, get registered and get certified as they need to. So in addition to the business.nj.gov website, you can also contact the Business Action Center. They are the ones that, those experts there really have a strong familiarity and grasp of the certification process for some of our diversely owned business categories. And the Department of Treasury also has a great deal of resources and information that's going to be useful for a number of businesses as well. And if you're looking for some general support for businesses, contacting your Chamber of Commerce. I mean, there are multiple chambers of commerce in New Jersey. There's a statewide one, and as well as chambers that are affinity-based chambers of commerce as well. And I know there's a business development center, and some localities even have a business development center specific for helping entrepreneurs set up shop in those municipalities. So we encourage you all to do your research and to really reach out to find which resources are going to be most useful for you as we move forward here. And so now we'll dive into some of the Q&A that we have. We have a lot of questions that have been submitted, and we'll try to get through as many as possible. But if your question is not answered this evening, don't worry. There will be other opportunities to have your questions answered. We are also monitoring the Q&A for questions that can be added to our website. So the questions you provide help shape the information that is relayed to not just you, but to everyone in New Jersey. So with that, I will hand it off to our Executive Director for Q&As.
Great. So I'm just going to start with, because we did accept questions submitted in advance. So I'm going to start with some of those, and then we'll move into some of the questions that have been submitted here tonight. So first, when will the application window open? How long will the application window be open? As I said earlier in the presentation, the process that we're going to have here for recreational business, like cannabis business licenses, is going to be dramatically different than what we've had under medical. So in the past, there's been an RFA with an open date and a close date, and everybody had to submit by that close date. Here, the CRC, once the application's open, and as our chair mentioned, there's going to be a notice of application acceptance, which will spell out the date on which we start accepting applications. Once that opens, the CRC is going to be accepting applications on a continuous rolling basis, with some sort of key limitations. So number one, that notice of application acceptance will be able to specify, the timeframes for when certain applications are submitted, i.e., we may specify that we'll focus on cultivation and some of those higher up in the supply chain businesses first. That will be in the notice of pre-application, but otherwise it's going to be a continuous rolling process. Importantly, social equity businesses, diversely owned businesses, and impact zone businesses will be prioritized, which means that essentially, even if they don't apply right off the bat, they will jump ahead in line according to that priority to be reviewed. As far as how long the application window will be open, again, continuous rolling basis until the CRC notices that it will be closing, that application window will be open. So our chair covered impact zones that will be released. What comes first, the state or city application? And I think this question really gets at, we've seen some municipalities setting up, local licensure processes. The statute allows them to do this. Whether we're talking about a city application or seeking, municipal approval from a city or town, the answer really depends. If you're applying for a conditional license, site control, local approval, and zoning are not required. Certainly, it would be good to be in process, given you have a maximum of 5 months from the time you're approved as a conditional license holder, but it's not required. If applying for an annual license, though, having that municipal approval is required. So you will need that in place if you're coming in for an annual license. So you have options. You can do it either way, and it's important to understand those two pathways. Can you upgrade from a micro business to a standard business? Yes, the CRC rules enable micro businesses to convert to standard businesses if they can justify the necessity of the increase in capacity. And I would refer to the rules and information on our website for more information on that. Do alternative treatment centers count against the 37 cultivation licenses being issued? So what this references is the law caps the number of cultivation licenses that can be issued in the first 2 years following the signing of the law. So essentially, by February of the end of February 2023, there will not be a statutory limit on the number of cultivation licenses, but until then, there is. The answer is alternative treatment centers may count towards that 37. The question is, can they qualify as an expanded ATC? And that is also in our rules. And what that means is they have to certify that they have adequate supply, they have the operational capacity to serve additional customers beyond their patient population, and they have municipal approval for operating as a cannabis business. The CRC is only authorized by statute to issue those 37 cannabis cultivation licenses before 2/22/2023. And if an expanded ATC is issued a license, then certainly they would count towards that. Importantly, micro businesses do not count towards that limit. The other thing I'll note is the statute expressly allows the commission to accept and process applications in excess of that limit of 37 while that cap is in effect. When will my town issue an RFP? When will they decide how many licenses to allow to operate, and how will municipal preference work? As our vice chair covered, municipalities have a good deal of authority over many factors here regarding the operation of cannabis businesses, including the numbers, the types of licenses allowed, and the hours of operation. Interested parties should reach out to your municipality to determine if they have passed any ordinances that either allowing or restricting the operation of cannabis businesses. When it comes to preference, though, the submission of municipal preferences in the CRC's licensing process will be outlined in that notice of application acceptance. So for both applicants and municipalities, though, it'll be clear in that notice as to what we'll be looking for as far as municipal preference. Will the CRC allow edibles? The CRC's initial rules allow for many ingestible products, lozenges, drops, tinctures, other forms as approved by the commission. And in the future, the CRC intends to explore the addition of more perishable goods in edible forms. But the production of such perishable goods may implicate regulatory oversight from other state and local authorities as well. For example, when you talk about commercial kitchens, the Department of Health plays a role. The local health department plays a role. So, we need to do some due diligence there, make sure that when we open up those opportunities, businesses are clear as to how they comply with the law, and not only the laws under the Cannabis Regulatory Commission, but broader laws regarding food safety. When will the CRC allow home grow? The CRC still does not have any authority at all in regards to home grow. Home grow requires a change in the law, and we do not have authority to do that. So those were some of the highlights of the initial questions that were submitted in advance. Now we're going to go to some of the questions that have been submitted here tonight, and I'm going to kick it over to a member of the team to select some questions and throw them up, and then myself and our vice chair are going to do our best to answer them.
The first question up. As you know, many states are dealing with laboratories falsifying testing results such as potency and contamination. Will you be auditing testing labs, and how so?
So, what we see with testing labs in other states and lab shopping, it's certainly concerning. We've set up comprehensive rules for third-party labs in New Jersey. We have some mechanisms in there that will help us do that. So, for example, labs will have to reserve a portion of any sample that's tested. That can certainly be looked at for QC, whether by a state lab or another lab. It's something that is certainly high on our mind. We want to make sure that consumers can confidently rely on the test results that they receive when they purchase a cannabis item.
Do consumption lounges fall under any of the categories?
Consumption lounges are not included in our initial rules. That is another facet of the law that will need to be added as we move forward with regulations.
But notably, the consumption lounges by statute do have to be attached to a retail space. I've heard anecdotally about some individuals who were hoping to set up a consumption lounge as a standalone operation, but the law requires consumption lounges to be attached to a part of a retailer. So we can't have consumption lounges operating on their own. And this is another area where municipalities are going to play a hefty role because they also have to allow for consumption lounges.
The next one, I'm going to combine two questions. It's about how the priority review process will work. One person says, can you explain what you mean by priority review? And another is asking, how will social equity, diversity, impact licensing applicants be prioritized against conditional license applicants, since you say they're both taking precedence?
So I'll start, and then if anyone else has anything to join, they can jump in. So think about it this way: the commission receives 100 applications. They are all businesses that don't qualify for one of those designations. So there's a line of 100 businesses, and they're all essentially in line based on the time they submitted. And then you have a social equity business come along as 101. Well, 101 is going to get bumped up to 1 in that line. And that's how that, roughly, I think how the priority is going to work. It's going to be spelled out in much more detail in the notice of application acceptance, including how the different priorities will work, whether it's, a social equity business versus diversely owned business versus impact zone business. Also how priority between conditional applications and annual applications will work, as well as micro businesses and standard business applications. But roughly that's how it would work. If somebody comes in with one of those priority designations, they get bumped forward in line and their application gets reviewed, processed, and potentially either approved or denied prior to businesses that don't qualify for that designation.
Follow up on that one. In order to get minority certification, a business must be certified by the Division of Revenue and Enterprise Services, but they typically ask for previous tax returns. How do you get certified if you're a newly formed business?
I'll jump in on that one. So we've had a few conversations with the folks who process these applications, not just to let them know about what's happening at the CRC side and the volume that they should anticipate of incoming applications that they should anticipate. But we also asked this question as well. We wanted to understand the process, particularly for those newly formed businesses. And so if you are a newly formed business seeking certification, then those 3 years tax returns obviously would not apply to your entity, but you will just have to submit a paper application to the Division of Revenue and Enterprise Services And they'll look to see if there's any tax information for the owners that can be provided. But the online system, their online system, unfortunately doesn't allow for newly formed businesses to submit their information because they won't be able to move forward in the online system past the tax return field. So if you're a newly formed business, you'll have to submit a paper application to the division, but you can still get certified. So I don't want anybody here leaving thinking that there's no hope for these newly formed businesses. You can get certified even if you are newly formed. So definitely work with and contact the Business Action Center and the Division of Revenue for more details.
What percentage tax is taken out for the social equity fee?
So the social equity excise fee is initially set in rule it kicks in at 1/3 of 1%. And then, the commission would have to approve any increases beyond that. The statute allows the social equity excise fee to be set based on the average retail price of cannabis. So when the price is high, say around $400 per ounce, then the social equity excise fee would be capped at no more than $10 per ounce. And as the price drops over time, then the social equity excise fee, the commission would be able to increase that based on the levels that the legislature set for that fee.
Can you apply for a conditional license but have site control and municipal approval?
Sorry, can you repeat that question?
Can you apply for a conditional license but have site control and municipal approval?
Sure. Yeah, there's no, that would be in excess of the requirements, but there's no reason why one couldn't go that conditional route. Absolutely.
And does a conditional license automatically convert to an annual as long as the requirements are met?
There's a conditional conversion process, conditional conversion application process that's outlined in our rules. It's similar to a full annual application, but as I mentioned earlier, there are some parts of the annual application that are not a part of that conditional conversion application. It focuses really on the standard operating procedures that make up the cannabis business operating manual that our compliance team is going to want to see, and really focuses on those key components of running the business.
Jeff, can you talk a little bit about the distribution versus delivery license?
Yeah, so the way that the statute envisions distribution and delivery, they're both transportation related, both related to delivering product, but distribution is from business to business and delivery is from business to consumer. So, distribution could go from, a cultivator to a manufacturer, or a manufacturer to a wholesaler, or a manufacturer to a retailer, whereas delivery service would have to go from a retailer to the end consumer. Delivery services have to act on behalf of a retailer, so they can't, in essence, act as a retailer themselves. They have to be partnered with a retailer. And I'll note that the statute sets both up as essentially options. So cannabis businesses can undertake either distribution or delivery on their own, or they can contract with external entities once those licenses are available to do those activities for them.
How do I find out which New Jersey towns will have retailers for recreational cannabis? So
I'll just say, I'd say reach out to the towns that you're interested in and ask them for their ordinances. I can tell you that it's a fastly changing landscape right now. But something we're working on at the CRC is how to help potential applicants with some of that information. So I don't have anything concrete to share now, but we know it's a need and it's something that we're looking into.
Well, what if my town council voted no, but the mayor vetoed? What happens now?
I think that, Under, oh, go ahead, Vice Chair.
No, go ahead. Go ahead.
So
Richard.
under the statute, if a town does not have an ordinance in place by August 21st that bans any particular cannabis business, then all cannabis businesses that aren't banned would be allowable in that municipality. So if we're thinking about a municipality that tried to enact an ordinance in this space but it was vetoed, then that ordinance was not enacted. And so unless the municipality had another ordinance in place by August 21st, then the statutory provisions would kick in, and thus any class of cannabis businesses that weren't disallowed would be permitted. The statute also provides like a default zoning area in which those businesses would be permitted. So we encourage folks to either go to the CRC's website and check out our FAQs where we do special lay out what that default zoning areas are, or go to the statute because it's listed there.
So can a municipality opt in after they opted out?
Yes. Yes, they can.
Yeah, certainly, in any of the questions when it comes to ordinances, municipality will want to consult their attorney, but as far as our regulations go, we note that they can pass and update their resolutions, and that includes opting out and then opting back in. I think where it's not the case is the reverse, so where they haven't done anything and then are automatically opted in according to the law.
Do New Jersey retailers have to buy from New Jersey cultivators?
Yes, it is indeed. Cannabis remains illegal federally, and the federal government regulates interstate commerce. And I would not recommend anybody engage in interstate commerce of any sort as it pertains to legal cannabis in the state of New Jersey.
As far as the application and getting supported documents from the municipalities go, do we need to have two separate letters, or can one letter signed by the mayor that states that zoning approval is met? Was that enough? And can I get a letter from an executive member instead of the mayor, like the director of, or somebody like the director of economic development?
So there are key, there are provisions related to this that are spelled out in the law and in our regs. And, I think some of these specific items are going to need to be addressed in the notice of application acceptance, as well as, corresponding questions related to that. I think it's very case specific on the particular town, the town's form of government. So, it's hard to answer that hypothetical.
Section 173067C3 states that the microbusiness license applicant or license holder shall employ no more than 10 employees at a time. While the number is feasible under most license types, cultivation is substantially more labor intensive, requiring more employees. Is this accurate for all classes of license holders?
Yes, that limitation on the number of employees is spelled out in statute, and that is not something that the CRC can get around. So if you are a business that needs more than 10 employees, then you would not be able to be a micro business. Similarly, if you need more than 2,500 square feet of space, you would not be able to be a micro business. So you would need to be considered a standard business.
If it has to be a New Jersey cultivator, this is a follow-up to the previous question. If it has to be a New Jersey cultivator, can it be an existing cultivator that supplies for medicinal, or do they need to be adult use license, cultivation license C?
If we're talking about, recreational cannabis, then they would have to be licensed as a class 1 cannabis cultivator.
What would be the cause of the non-renewal of a license?
I mean, that's tough to say because it's, I guess from the CRC's perspective, non-compliance, if somebody doesn't pay their fees, if somebody is substantially out of compliance with our regulations. And I think if you look at, and I don't remember the section off the top of my head, but it's at the very end of our rules. I think it might be section 17, but deals with enforcement and licensure suspensions and things of that nature. So, if you're looking at what conditions would lead the CRC to, either suspend a license holder or issue a fine, that's where you would want to look to find that information.
Under conditional licensing, you had stated that somebody applying for a conditional license does not need to have site control at the time. Would you elaborate on what that not having site control means?
So that means they don't have to essentially be, lease or own a property. They could, they could have a property identified, but they don't have to enter into a legally binding agreement to give them, sole control of that site if licensure is to occur. And, whether that's a lease ownership or, some binding letter of intent, all those things tend to cost money when it comes to landlords or sellers. And so with a conditional application, they can wait to get initially approved by the CRC before going and gaining site control and municipal approval.
Will the conditional licenses issued be part of the 37 cultivation license, or will those be in addition to the 37?
Oh, sorry, I was trying to unmute. So the conditional licenses are temporary. I think we're going to spell out how they play with the overall caps for 2 years in the notice of application acceptance. So stay tuned for that. But again, conditional licenses are temporary, and they don't allow people to engage in the actual cultivation of cannabis. But they do allow a business to start that process and get ready and begin implementation with an initial approval from the CRC.
Will there be priority applications for laboratories that are minority owned as well?
Again, I'm going to have to defer to the notice of application acceptance there, which is going to spell out priority in much greater detail, whether it's, how that works with cultivators, manufacturers, testing laboratories, et cetera.
Here's a question. I have seen some language, I think you may have answered this already, but I've seen some language in the regulations that says as long as a licensed worker is in the company vehicle that they can transport cannabis from A to B. If true, does this affect the distributor license? What are the regs for distribution license?
So the regulations for distribution licenses are, the comprehensive regs are going to need to be included in the next regulatory package from the CRC here. There are regulations on secure transport, which is probably what this question is referring to. And so certainly they do reference distributors, because if we are able to license distributors at some point before that, there are additional rules done, we do have enough, at least we have some under secure transport and some other provisions that would be applicable to distributors, but it is our intent to have those included in our next set of regulations.
Will application fees be refunded if their license is denied?
So importantly on this one, the application fees are set up into two parts. So one is the initial application fee, which is non-refundable. And then the second one is only paid if the applicant is successful. So rather than charging a full, like now we have a $2,000 application fee plus, non-refundable, now and that's under medical. Now essentially there's that first fee, which is, very low in many cases, that is non-refundable, but you will only have to pay the additional part of the application fee if successful, and that would be assessed along with a licensure fee. So it would really come at the end of that process.
How will you address stores or individuals selling cannabis illegally, typically in the guise of a free gift for purchasing something else?
So I'll hop in and take that one. The statute does have some language around gifting. Regulated businesses are not permitted to gift cannabis, but private individuals, there's no limitation on private individuals gifting amongst themselves, so long as they are gifting to an adult who is over the age of 21. As for unregulated businesses, CRC is keeping an eye on businesses that are holding themselves out to be cannabis businesses, but are not licensed or regulated by the CRC, and we're working with the relevant authorities to handle those businesses at the local level.
When the application process opens, can we apply for different classes at the same time? Then based on what we get approved for, we choose what we want to do?
Yeah, there are some restrictions that are laid out in the statute for ownership of multiple classes of licenses. This is that is also spelled out in our FAQs on our website, so people can go there for more detailed information on that. But in a nutshell, for a period of, I believe it's 2 years, individuals will not be able to have a cultivation license or manufacturing license plus a retail license. If you are a cultivator, you can also have a manufacturing license, but you cannot have a retail license. This is a provision that essentially essentially does not permit a vertical integration in the adult use market at the outset of establishing the industry. But as I said, after that period of time is up, then individuals can own multiple licenses.
Some municipalities are charging admin fees to obtain a letter of support. Is this allowable?
Go ahead, Vice Chair.
That's yet to be worked out, right? Look, the municipality, they are the masters of their kingdom, right? And until we work this out, they are.
So one thing to note, as we noted in our rules, municipalities are bound by statutes regarding the reasonableness of their fees. And so, I think that's an important thing for folks to consider. Again, they do have, as our vice chair mentioned, they do have a good amount of leeway under the statute as to, what they can and can't do. I think, best thing to do is to, consult your attorney as to what the statute says, and they can advise you accordingly. And then, we'll try to provide resources to both municipalities and applicants so that, again, as I said, as our vice chair said, we got to be in a partnership and make sure that there's sort of communication and that applicants have as easy a path with both, both at the state level and the municipal level.
Yeah, and I think across the board, over the 556 municipalities, you're going to have an array of fees from very high to very low. It's all going to depend on what that municipality wants to charge right now. But again, as the executive director mentioned, that's something that we have to work with on the municipalities, with the municipalities.
Will you immediately implement a state inventory system?
So there is a state, as noted in our rules, there is inclusion for a state inventory system, and our intention is certainly to implement that and have that online as quickly as possible.
When considering to apply conditionally versus annually, is it possible that an applicant could be granted a conditional in a municipality that only allows 5 licenses, and then within 5.5 months, all 5 licenses would be granted to annual applicants, making the conditional licenses null and void?
So again, so conditional license holders are able to change their location. So they have to have a site identified. But again, site control, municipal approval is not required. So, certainly there's a possibility that something like that could happen, but, conditional license holders can change their location. Also, as per our rules and as will be spelled out in our notice of application acceptance, conditional applicants will be prioritized over annual applicants, certainly at the CRC level.
And I'll just add one additional point, and that is really the purpose of a conditional license is to help businesses get moving, but it is not in and of itself any guarantees that the business holder or the permit holder will ultimately have an annual license. So really, there's an incentive here to make sure that to push business owners to move as quickly as they can to get all of their ducks in a row, especially if they are hoping to set up in a jurisdiction that has limited the number of the cannabis businesses that will be allowed in that jurisdiction.
Right. The conditional license provides the opportunity, as the Madam Chairwoman said, is to get the businesses to get their ducks in a row. That 5.5 months and then the 45 days extension.
I would also note that, I think, at least it's my hope that municipalities will look at the conditional licensure as an opportunity to see a pool of applicants who have already been at least partially vetted by the CRC and given an initial approval. Certainly, when it comes to their business plan, regulatory compliance plan, we will have looked at that and made sure it's compliant with our rules if they're issued that license.
And besides the municipality, there are other considerations such as leasing, building and land lease that may require time to get completed and get signed off on.
We mentioned before that a cannabis business cannot use an alternate name. Does that mean that there are no DBAs are allowed?
Yes, that's correct.
Yeah. I believe I covered that. Yeah, I believe I covered that on one of the slides.
Which New Jersey banks allow cannabis company banking?
So I don't have them off the top of my head. I do know there are at least 2, I believe one in South Jersey, one in North Jersey. I think we're going to work with state partners that regulate banks to see if we can, get that expanded. But banks are in a tough, like any business that's partially federally regulated and state regulated. As long as it remains illegal federally, it's going to be hard to get a lot of banks to jump into this space. But certainly we're going to try.
Sounds like a good Google question for me.
Yeah.
Yeah. But also, don't be afraid to ask your own bank or a bank that you're considering if they are interested in doing business with prospective cannabis businesses, because some banks just might not want that information publicized widely, as Director Brown mentioned, but they may be willing to share more insight into their the available options more privately.
Two more questions. We got so many questions, more than we could possibly answer tonight. So we are coming on 9 o'clock. So the last two. During his part of the presentation, Co-Chair Delgado mentioned that insurance could be needed. Would an insurance quote be enough?
Executive Director.
Yeah, so I think there's going to be two pieces here. So first, there's going to be what's necessary for the application, and then there's what's necessary to actually operate the business. I'll note that when it talks about operating the business, the CRC does, I think, require some types of insurance, particularly around automobile insurance, if you're engaging in deliveries or distribution. As the Vice Chair mentioned, municipalities may require businesses to have certain types of insurance. As part of the application process, conditional licensees, I believe, have to have a plan for obtaining liability insurance. I believe that's prescribed in statute. It's those two things. And there's a lot of types of insurance that is probably good practice to have as a business that may not be required by the CRC, but certainly you should look into. I know with banking, likewise, insurance can be costly for cannabis businesses, but it is important to have your business protected and have your consumers protected in the event and your workers protected in the event that anything unexpected is to happen.
Can the word cannabis be in the company name? Are there any restrictions around naming a business?
So I'll jump in. So the CRC does regulate signage and names, and so I believe we'll have some more specific guidance to be issued with respect to that question. But taking a look at the statute, remember that there are, depending on what your business is, for example, if you are looking to operate a delivery service business, then the vehicles cannot clearly indicate that the vehicle is being used for cannabis purposes. So folks should be smart about their naming, especially if they are unsure as to whether or not a particular name that is under consideration may cause some unneeded strife or stress for the business and its workers. But we can certainly take another look at this question and provide more detailed information at a later time if needed.
Good question.
And that was our last question for the evening.
Thank you, Ms. Blake, and thank you to everyone who submitted questions. There were nearly 500 questions submitted this evening, and obviously we certainly try our best to answer as many as we possibly can. But as was mentioned before, if your question was not answered this evening, that does not mean that it will never be answered. There will be additional opportunities to have your question answered, and we will provide additional information in our notice of application acceptance and in the pre-application information session. So please stay tuned for those two items. Thank you all for joining us and for sticking with us for these 2 hours. We are recording this session and it will be posted on our website soon, I believe tomorrow. So please feel free to share the link to the recording with others who weren't able to participate. But thank you again. Big thank you to our staff at the CRC for their help in getting this together and advertising this webinar. We're really thrilled about the participation that we had this evening. I think it was above, went well beyond what most of us would have expected. And we look forward to seeing you all again and hearing from you again. But thanks so much, and I hope you all have a great evening.
Bye, everyone.